All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Well, good morning. Thank you, Madam Clerk. Welcome to the North Carolina Court of Appeals. We have your panel for today. I'm Judge Toby Hampson. To my right is Judge Jeff Carpenter. To my left, Judge Jefferson Griffin. We have one case on the calendar for argument this morning in COA 23885, State v. Carwile. It appears the parties are ready to proceed, and we'll hear from the appellant.
Good morning, and may it please the court. My name is Chris Haney, and I represent Mr. Carwile. I'd like to reserve 5 minutes for rebuttal. This case is about what rules apply when a masked man attacks you in your home at 5 a.m. with a chainsaw. The North Carolina General Assembly, building on centuries of common law, has said in NCGS 1451.2b that a person in his home is presumed to have held a reasonable fear of imminent death or serious bodily harm to himself if the intruder had unlawfully and forcibly entered a home. In that scenario, the presumption controls unless and until the state proves beyond a reasonable doubt that the intruder has not only exited the home, but has discontinued all efforts to unlawfully and forcefully enter the home. The jury instructions here were fundamentally flawed because they had the judge decide what should have been a jury question, and because they did not tell the jurors that the presumption of reasonable fear allowed Mr. Carwile to use lethal force unless the state satisfied the conditions given in 1451.2c beyond a reasonable doubt. In this case, most notably the fifth condition, whether the state proved that the intruder had exited the home and discontinued all efforts to enter it.
But one of the threshold issues we have here as it relates to that issue is that trial counsel conceded that defensive habitation did not apply in this scenario. So how is that not, at a minimum, inviting error? Or
yes.
Maybe at a maximum inviting error, but at a minimum, how do you get past the plain error standard here?
Yes, sir. I'll start with just one point about, I certainly agree with the court that the record says that after the state rested, trial counsel said, well, I don't think that, to paraphrase, I don't think that the Castle Doctrine applies. But I do think it bears noting that this was only what the transcript titles a preliminary charge conference. Mr. Carwile and the other witnesses for the defense had not yet testified. And so at the point when counsel said that, he wasn't in a position, I mean, he could have forecast what the evidence was, but the court hadn't heard all of the evidence. So I do think that bears noting. I think if the court is troubled by that, it does go right to one of the fifth issue raised in the briefing, which is ineffective assistance of counsel. I think this is one of these rare cases where this court does have what it needs to reach this claim on the merits. Because in this case, it was very clear the defense's strategy was defensive self or others or nothing. Once Mr. Carwile and his attorney knew that's what they were going to do, the reasonable attorney's job was to go for the jury instructions that gave his client the chance of the best possible verdict, and getting the Castle Doctrine instructions here is exactly what would have done that.
But isn't that part of why we really want these issues fleshed out in the trial court first, right? Litigated in the trial court first, because I think the issue that's at hand here, which is the scope of defensive habitation, the scope of the Castle Doctrine, when does it cease to apply? We don't really have the full record, the full argument before us from the trial court.
Well, I think in this case, Your Honor, this is not a claim where the question is what was the trial attorney's strategy. I do agree there are cases where this court would need to know that, would need to have testimony from a trial attorney.
But even just to like, at what point does the Castle Doctrine stop?
Sure,
Right?
and I
Is
think
it the edge of the curtilage? Is it, in the used car parking lot? Where does it end?
yes, sir, and I think that's a legal question that this court doesn't, with all due respect to the trial court, that's the question that this court can answer. And so a mistake as to law first of all, that's not reasonable trial strategy. And as far as reaching the merits of of the scope of the Castle Doctrine, I don't think this court needs to remand it for that. I think this court is in a position to address that issue squarely. And I think that, Judge Hampson, your question got to really the heart of the Castle Doctrine here, which is what was the proper procedure for the judge to decide whether it applied? And the answer I would give to that is that so long as the evidence taken in the light most favorable to Mr. Carwile showed that an intruder or intruders had unlawfully and forcefully entered his home, I'm using the language from 1451.2b, then he had a reasonable fear for his life, and the state had to rebut that presumption beyond a reasonable doubt. And to the court's question about the significance of the fact that some of the events here took place in a used car parking lot, I think the language in the statute really addresses that question, because the statute lays out the idea that so long as Mr. Carwile was in his home when he was attacked, the presumption attaches. And what makes the presumption end, it's not a question of location, because the General Assembly did not include any sort of location-based term in the statute. The General Assembly included language saying what the state's burden is to rebut that presumption of reasonable fear, but it did not say that it ends at some bright line location. And I certainly understand that the parties have talked in the briefing about the meaning of the word occupant. And I think the word occupant should not be addressed as some sort of bright line rule that, as I understand the state's briefing, that you are an occupant when you are in your home, but somehow you stop becoming an occupant of your home when you leave it. I think that understanding, first of all, it doesn't square with the language of the statute, which again talks about when the threat begins, but it also doesn't mesh with all of the common law that's behind the Castle Doctrine. The whole point of the Castle Doctrine is that a person has an interest in being secure in his home and protecting his home, and that interest persists over time. And I know this is not a Fourth Amendment case, but I don't think anyone would dispute that right now I still have a property, I still have an interest in my home being safe, even though I'm not in it.
But you wouldn't receive the benefit of the Castle Doctrine self-defense.
That, yes, I suppose in the unfortunate circumstance that right now, if someone tried to break into my home, right now I don't get it. However, I would say the scenario I'm talking about now is fundamentally different because I'm not starting out in my home. But if we take the scenario you're imagining, let's say that after arguments are over today, just as I'm getting in my car to drive home, someone starts to break into my home. I walk home, I discover someone has forcefully entered my home. Once I'm in the home, according to the statute, I get the benefits of the Castle Doctrine. And those benefits continue until the evidence shows that the conditions, in this case we're talking about C5, are met. And so I think that the jury instructions, what they really needed to do was tell the jurors that's how they had to work through the issues. And I know in the state's memorandum of additional authority, they cited the Supreme Court's recent Phillips case, and I think that everything I'm saying is consistent with that case, which talks about the importance of the Castle Doctrine. The other point I would just note is that on page 25 of Justice Earle's partial concurrence, she talks about the importance of giving jurors a decision-making tree. And I think the rule that Mr. Carwile is articulating in this case is really what corresponds with the decision tree that she lays out, deciding whether there's an intruder or intruders who had unlawfully and forcefully entered, the language from 1451.2b, and if they did, then the presumption of reasonable fear applied. And if not, of course, then we get on to the regular self-defense conditions that are given in 1451.3. And as she says, if the answer is yes, the presumption applies, then it's up to the jury to decide whether the state rebutted the instructions. And I think it's really clear from her opinion and just the nature of who decides what in a self-defense case. The trial court in this case took something that should have been a jury question, whether or not the state had met its burden, and never let the jury get to that question, which is where the instructions ultimately should have led.
But isn't the purpose of the Castle Doctrine was protection of home and self within the home or the workplace, the motor vehicle? But the concept being that it ends once you've successfully defended your home,
yes,
one way or another, either by use of lethal force or the intruder ceases efforts to continue entering. Doesn't all the evidence in this case show that Mr. Easter, the victim, was in retreat?
I would agree with have no argument with the court's description of the law, but I think I'd see the evidence differently. It's important to say when the court's deciding what instruction should have gone to the jury, the evidence is viewed in the light most favorable to Mr. Carwile. And I think the evidence viewed from that perspective did support giving the instructions. Mr. Carwile's testimony was that the intruder never abandoned his efforts to enter the home, and I'd refer the court to pages 582 to 83 and 586 of the transcript. But we're not...
Even when the intruder was in the, basically subdued in the parking lot of the used car lot, defendant's position is, no, he was still trying to get in the house even though I was out there in the parking lot with him slamming his head into the asphalt.
Yes. And I would just add some nuances to that if I could, Your Honor. First of all, when we're talking about that scenario in that moment in the parking lot, the video does show that Mr. Carwile was using lethal force against Mr. Easter. There's no disputing that. The video also shows that before Mr. Easter went down on the ground, he was very much trying to take Mr. Carwile with him and continuing the fight. So I think
that's in my view, and I don't want to put words in your mouth, but it would seem that that's a different question than whether if he's still engaging in combat, that's one thing, but the question is he still trying to get in the house?
And I think, Your Honor, that question, that is an important question. And I think it was one for the jury to decide. I don't want to sidestep the question. I just think that's a fact question that the jury should have decided whether or not the state carried its burden to show that the conditions in C5 had been met.
So does the record indicate how far the parking lot was from the home?
About 500 yards, Your Honor. And if the court wants, I don't have a page citation handy, but I'm happy to look for one if that would be helpful to the court. But Your Honor, I can understand why the court would be curious about that fact, but I don't think distance is dispositive here. I think that The question is whether there was enough evidence, taking it in the light most favorable for the jurors, to think that there was a home invasion that began in Mr. Carwile's home, that continued in that Mr. Carwile was struggling with the intruder, trying to subdue him, and it continued into the used car parking lot. And I think the evidence taken in the light most favorable to Mr. Carwile does show that. I think we had talked a little bit about the video, but I'd also like to talk about some of the state's testimony. For example, in the briefing, the state talks about page 228 of the transcript, where it is true that in one particular line, Ms. Carwile says that Mr. Easter backed up with his hands up. But I also would just note that on page 223, Ms. Carwile described the fight between her home and the parking lot as an ongoing altercation the whole time, which in my mind, if the jurors had believed that testimony and thought it was, they could have looked at that testimony and thought that the state had not carried its burden. They could also look at, on the same page, her saying an ongoing transaction the whole time between the house and the car lot. And even when the state was questioning her, she could not say exactly when Mr. Easter dropped the wrench and the sock with rocks, which certainly could be deadly weapons that she was scared of. On page 227, she said, "I'm not sure. Everything was happening so fast." And I think what she was describing was a very scary moment where someone showed up at her doorstep at 5 a.m. wearing a mask with a chainsaw after she knew that Mr. Easter had recently come to their home asking for a ride to get a gun, that he had had a past conflict with her husband, and that he had said that I'll be back to settle things my way, and that he literally showed up in her home with weapons up his sleeve. And I think first of all of that evidence taken in the light most favorable to Mr. Carwile could have been enough for a jury to think that, no, the state did not carry its burden under C5, that Mr. and Ms. Carwile were attacked in their home, they had a reasonable fear, and that Mr. Easter never abandoned the effort to break into the home until he was fully subdued. The statute authorizes, in the event of a home invasion, Mr. Easter to use deadly force. And that's what you see on the video, and I agree, it can be a difficult video to watch. But the General Assembly, by enacting 1451.2, gives homeowners the ability to protect themselves, and once a home invasion starts, the homeowners get the benefit of that continuing presumption, and it's not a matter of physical location. It's a matter of whether the state meets its burden.
Well, let's move to the prejudice piece. How do you establish this rises to the level of plain error, since the trial court was never asked to submit that instruction to the jury in the first place?
Yes. So I'll talk about the three prongs that we have from the most recent Rabus case. So I think it is fundamental and exceptional because we're talking about jury instructions that are not just about a peripheral issue in the case, like whether there's an interested witness, for example, or 404B. We're talking about jury instructions that reflect an important public policy enacted by the General Assembly that would have presented either a complete bar to conviction or would have given the jury, and to get to that complete bar, would have told the jury the most important issues about the case. So I think that's how we satisfy the fundamental and exceptional prongs. As far as there being a different outcome more likely than not, I think it's important to note that when the trial started, and I understand we're talking about plain error, nonetheless, when the trial started, as the trial judge correctly told the jurors, Mr. Carwile was presumed innocent, and the state had the burden to overcome that regardless of whether Castle Doctrine applies. The state had that burden. In all of the evidence, we have Mr. Carwile's testimony, and then we also have all of the testimony from the state, including the testimony from Ms. Carwile that I just talked about, the video that we've talked about, testimony from the landlord, her daughter, Mr. Chinalt, and all of this testimony is consistent on the fact that there is a terrifying home invasion, and I think jurors, if they had been given the additional guardrails that the General Assembly set out in 1451.2, more likely than not, would have reached a different verdict using the Castle Doctrine instructions. So I think Mr. Carwile has satisfied the standard for plain error.
But my recollection is the jury was given self-defense and defense of others and rejected those defenses.
Well, Your Honor, they were given partial self-defense instructions, but it's not true that they were given the accurate and complete instructions. And jury instructions are not adequate or complying with the law if they only give the jurors a partial description of what was happening. The General Assembly had a very specific flowchart that they wanted jurors to go through in a self-defense case. That's what we know from the Phillips case and Justice Earle's partial concurrence. And if the jury instructions don't give that information, the jury instructions do not do what they are supposed to do. And so I think the jury's verdict in this case, it shows that they did not believe the state had met all the elements of first-degree murder, but it doesn't show that they agreed that the Castle Doctrine did not apply because they never had a chance to apply it.
Is it your argument that if a trial judge is instructing on the sort of self-defense doctrines, that the Castle Doctrine always has to be submitted as a threshold issue?
No, Your Honor. I think it has to be submitted to the jurors, again, under those conditions I talked about, when the evidence in the light most favorable to Mr. Carwile or the accused person showed that there is an intrusion and the language of 1451.2b is satisfied, then the instructions come into play. But I'm not saying that in any and all self-defense cases they do come into play. And I think so long as we're talking about the idea of what is the outer limits of the rules that Mr. Carwile is proposing, the parties have talked about, or the state has raised the idea of vigilante justice. And I would just say the rules that we're talking about only apply if a person is in their home when they are attacked. And we already went through the scenario wherein right now, for example, if there's an ongoing home invasion at my apartment, I hope not, but I can't use Castle Doctrine. But if I go into my apartment, discover it, and then end up in the unfortunate scenario that ensued here, I think the Castle Doctrine would apply. So we are talking about a narrow set of cases, but in those narrow set of cases, the precise rules really do matter. So if the court doesn't have any other questions about the Castle Doctrine, I would just want to briefly discuss the requested special instructions that were important because they showed how a reasonable person in Mr. Carwile's position would have seen the intruder's use of force. An intruder who is allowed to fight back to some degree under the law is less threatening than an intruder who is not allowed to fight back simply because the intruder's force takes on a different character. And the point of jury instructions, like we were just talking about, is to put the jurors in the defendant's shoes and tell them not just what rights the accused person has, but what would guide his perception of the other person in the fight. And the jurors needed to know that the intruder had the limitations given in the special instructions. And I know we've just been talking a great deal about plain error, but I'll just note this is an issue where the court doesn't have to reach as high of a burden. It just has to show prejudice under the normal standard.
What authority do you point to that would require a trial judge to give this particular special instruction? Like, not just special instructions generally, but what legal basis is there to instruct a jury on, use of force by the victim.
Yes. Your Honor, I think it's just the language of the statute. The language of the statute, 1451.3, it just says person. The justification described in the above statutes is not available to a person. The General Assembly could have said the word defendant, accused person. It could have chosen any number of other words, but it chose the word person, and I think that really matters because the self-defense statutes are very nuanced, complicated statutes, and I think trial courts should give jury instructions that reflect all of those nuances. And I know the Macklemore case that's cited just uses the word defendant, but the reason why is because that case did not reach the issue here. This is a case that squarely raises the issues of whether the intruder is the one who's allowed to use defensive force. I think the General Assembly has already answered that question in the negative, and I think the jurors should have had a chance to know that. So I see that I'm down to about 5 minutes. I'm happy to answer any other questions. Otherwise, I'll reserve the remainder for rebuttal. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Caden Hayes. I'm with the North Carolina Department of Justice, and I'm representing the state in this matter. Your Honors, defendant's brief raises a number of issues, but there are really two dispositive issues before this Court today. Whether the Castle Doctrine applies and its associated instructions, and whether the omission of those instructions prejudices the defendant. The answers to both of those questions is no. I do want to briefly touch on a couple things that my colleague represented earlier. First and foremost, Judge Hampson, you were right on the money. This is invited, which pretty much stops the inquiry in its tracks. There was a lot of briefing and discussion done because there is also an ineffective assistance of counsel claim, and I will proceed to discuss why the Castle Doctrine doesn't apply here. But I do want to note at the outset that this was invited. Your Honors, as our Supreme Court explained on Friday in the Phillips opinion, the statutory Castle Doctrine is both a powerful but narrow doctrine. It allows an occupant, a lawful occupant, as the Supreme Court reiterated time and time again, to use, quote, deadly force, whether to prevent unlawful entry into the home or to terminate an unlawful entry by an intruder. It does not, however, permit an individual to back a would-be invader out of the house, leave his home to pursue that invader, back that invader over a road, through a neighbor's yard, into a parking lot. It does not allow him to then pin that invader to the ground, beat him to death, all while his wife and friend are begging him to stop. The plain language of 14-51.2 makes this clear in two ways. One, through its use of the word occupant, and two, through subsection C5. I want to first kind of touch on this occupant discussion. In my colleague's opening statement, he described the legislation as stating an occupant is someone who is in his home, which is different than originally presented in the reply brief, where there was a lot of discussion about possessory interests. So I think he's right. It is in his home. That fits the plain language. It fits the word occupant's use in pretty much every other area of law, such as the Fourth Amendment, such as in, there was a case called Hedrick from our Supreme Court that was talking about the relevancy of certain evidence during a home invasion prosecution. And the Supreme Court noted that, quote, talking about this pillowcase that was used, it was a means of subduing the occupants who he knew lived there, delineating between occupants, one who are physically present in an area, and those who generally reside in an area. Additionally, this interpretation and definition, this plain language definition of occupant comports with the policy concerns. The Castle Doctrine is designed to protect oneself and one's family at common law. It was very limited. The General Assembly, in their prerogative, decided to expand it. But as I noted at the top, it did not permit this action. I wanted, though, The defendant spent a lot of time today talking about how there's a chainsaw at 5 in the morning and all these things. Certainly that must have been terrifying. But the defendant did not use deadly force at his house. He did not use deadly force on the road. He did not use deadly force in the neighbor's yard. He used it in a parking lot about 500 yards away. That is not the Castle Doctrine. The Castle Doctrine never applied because the defendant did not use deadly force at his house. So this idea that the Castle Doctrine is perpetual from the moment the invasion begins to when the victim is subdued or dead is not the correct standard. It is not supported by the statutory language. The question is an occupant. This is revealed in a number of ways, but I think the easiest example is perhaps through hypotheticals, and they pretty much write themselves. If someone tries to invade your home, for example, but then leaves and promises to return back the next night, are you really allowed to watch them go onto the road away from your property and then run them over with your car? This perpetual license to kill that defendant is kind of insisting upon. He seems to link it to this idea that if the fight is ongoing, then the defendant is allowed to use lethal force at any point. But that's not what the statute reads. It reads an occupant is allowed to use deadly force. The defendant was not an occupant at the time he used deadly force. Technically, he was trespassing into a parking lot that was 500 yards away. He cannot claim the Castle Doctrine privileges, and that is why his own trial counsel argued to the trial court that it simply did not apply. It clearly did not apply.
I think your colleague would argue that you're sort of taking the evidence in the light most favorable to the state, and that from the defendant's standpoint, the evidence showed more of just kind of like a continuing melee without any real break in the chain of events, without any clear effort to stop and cease the intrusion or the attack. How do you respond to that?
The quickest answer is, to be frank, that doesn't matter for the purposes of definition of occupant. For the purposes of that C5 subsection, which I will get to now, I think it's important to really look at that evidence. Defendant does claim that if we take it in the light most favorable to him, it proves that this was...
Or at least creates a jury question.
Correct, you're right, Your Honor. But if we actually read that, he's referring to one line of dialogue or questioning between him and his trial counsel on direct, where his trial counsel says, quote, "At any time did the individual in the mask and gloves turn and run away?" He says, "No, not that I'm aware of." Counsel follows up by saying, "Well, you were there." So the defendant then says, "No, not. I mean, I believe before it comes into the video that I fell down, so I didn't see him run. I just may be backing away where he's swinging something still, though, but not to leave." Judge Carpenter, you made a great point in that whether or not he's continuing a brawl is independent from whether he's trying to enter the house. There's no evidence to point that he was trying to enter the house. There is a minuscule amount of evidence that he was trying to continue this fight, but even that falls short when we consider this statement in its totality, because later on in his testimony, which is the other bit of transcript that my colleague referenced, his trial counsel asked him, "You backed him away. You backed him out of your house, right?" "Yes." "You backed him into the parking lot?" "Yes." Indicating he was the one aggressively moving the victim from this location 500 yards down the road. So if we really dive into this evidence, it's not there. It's a house of cards. The only evidence in the case is that the defendant or the victim had ceased all attempts. He had discontinued his attempts to unlawfully re-enter and forcefully enter the house.
That would be looking at the evidence in light most favorable to the state, not necessarily the testimony given by the defendant. So what would you have us do with the sort of continuation of things, not just on this particular date, but the visit before where there was the altercation and then the escalation by the victim in this case with the second visit? How many times do you have to let the now victim in this case come back before you get to extend that?
Well, Your Honor, to be frank, and again, trial counsel argued this below, it was saying that if the victim had opened up the door and the defendant had a shotgun and shot right then, we probably wouldn't be here. We almost certainly wouldn't be here. Had he done the same during any of these unlawful and forceful attempts, we wouldn't be here. But he didn't do that. He pushed him out of the house. He backed him out of the house. He backed him all the way through neighboring properties into a parking lot. So we're not in this world where it's a home invasion and everyone's terrified. Certainly I'm sure they were terrified at that moment. But it's not that. He could have, and I note too, when he began pursuing, if you want to use the word, or continuing this fight with the victim down the road, his wife was calling the police. The police were there when he got back. That was the more appropriate course of action. Once the defendant had left, or the victim had left the property, the defendant had left the property. This was a matter for police. It was not a matter for him to take justice into his own hands and beat him to death with a wrench and a sock filled with rocks. And so we get to, again, there is no evidence to support the idea that the victim was intending to return. Again, we have this one line of testimony that is somewhat contradictory with itself and vague. We also have a video evidence that no one objects to. There was no testimony that contradicted it, even from the defendants. And it shows the victim backing into frame up against a car. And there's a solid 5 seconds or so before the defendant comes into frame, kind of walking up to him menacingly as the defendant continues to, or the victim continues to try to back up. Then, of course, the wife enters the scene, and then later the friend enters the scene, and the attack goes on from there. So, occupant must mean someone who is within a protected area. The defendant was not in a protected area at the time that he utilized deadly force. There is not this perpetual license to kill if someone tries to break into your house. That just cannot be how our system works. And that cannot be what the legislature intended. And even if we were to say, okay, the presumption did apply, well, it was thoroughly rebutted and there was no evidence to say that it wasn't, thus that it was no longer a jury question. I read the case law on whether evidence must be submitted to the jury as almost an inverse sufficiency analysis. While the state normally has to show substantial evidence viewed in the light most favorable that the defendant is guilty, the defendant has to show substantial evidence that he's entitled to this instruction. It has to be more than suspicion. It has to be more than conjecture. Defendant offers nothing more than suspicion and conjecture that the victim was going to go back. There's evidence in the record that the defendant's or the victim's car wasn't even at the property when police seized it. So this C5 was rebutted, and so again, we're left with the Castle Doctrine doesn't apply here. And even if we were to say, okay, the Castle Doctrine should have applied, the trial court should have given this instruction, it's a jury question. Well, there is very, very little chance this would have prejudiced the defendant in any meaningful way. Setting aside, Judge Hampson, your comment about invited error, which the state strongly stands behind, there is certainly not doubtless, as the plain error standard under Reber established or reiterated. It's not doubtless that the jury would have returned a different verdict. We have the victim's or the defendant's wife testifying that the victim smacked the defendant upside the head with a chainsaw and then ran. Chenault, the friend, testified similarly. We have the victim's wife testifying about raising hands and the backing up. We have the defendant repeatedly reiterating that he was mad and he was wanting to beat him. His friends were trying to pull him off of the victim during this assault.
That's again, you're asking us to frame the evidence in the light most favorable to the state, which we're not permitted to do. It's got to be in the light most favorable to the defendant.
Well, Your Honor, so two things. One, I guess at this point I'm talking more about prejudice generally, which does involve the state's evidence, but two, there is no evidence to the contrary of these statements. I mean, maybe there's a little bit to the state of, okay, maybe he didn't back up to retreat, but even defendant acknowledges he backed up at points, whether it was the defendant pushing him and backing him up forcefully, or as he says here, whether he's backing up to still swing something. Regardless, this testimony is congruent with one another, and they all agree that at different points, the victim backed up. So the question of which light we take it in, there is no defendant's testimony here. There is no defendant evidence to support this. We have this offline that still supplies and goes with the rest of the state's case. But turning more broadly to the prejudice question too, where certainly we incorporate the state's evidence, and there is quite a lot of it. We also remember that the defendant was not exactly a very credible witness. He repeatedly stated that he was high on a number of drugs over the course of that weekend. He had been up all night the night before the murder. He was not asleep, as my colleague said earlier today. He was awake, him and his wife and others. So we have that. We also have him changing his testimony mid-testimony. He said that he originally, on direct examination, he said he didn't know who the attacker was, if it was Easter, until he pulled the mask off after Easter was dead. But then on cross, the very first thing he says is, well, maybe not. Maybe I knew it a little earlier. I can't be sure. I guess I was wrong. These inconsistencies are riddled throughout the entire testimony. And it's likely part of the reason the jury rejected the self-defense instructions that were given. As you point out, Judge Hampson, there were self-defense instructions given. And
But isn't one of the sort of lessons that we're learning from the Phillips case, that, you know, if the Castle Doctrine applies, it applies. And there's, you know, unlike, you know, self-defense or defense of others, there's not really that sort of common law reasonableness that kind of comes into question as to the use of force, or whether the use of deadly force was reasonable or not. That's not even a question. It's simply a flat-out immunity. I mean, that was the very issue on which Judge Carpenter's opinion and my dissent sort of joined the issue there. And so is there not prejudice in that if the Castle Doctrine applies, it applies? We're not worried about was it reasonable, were his actions reasonable? If he was defending habitation, deadly force is justified, presumptively.
I would disagree with that, Your Honor. While I agree with your kind of recitation of the Phillips opinion, I do think that's what it says as well. I can think of easily scenarios where the Castle Doctrine may have applied at one point, but ceased to apply long before the murder. I mean, if I try and broke into your house, for some reason you didn't use lethal force on me, and I run away, and I'm coming in here today, I don't think you're allowed to get over the bench and shoot me. And that would not be a jury question under, I don't think, any kind of reasonable interpretation of precedent. So there is a cutoff point. It's not just the moment it applies, the jury gets to hear it. There's still the question of, is it a jury question?
That's kind of what we're dealing with here. Where is the cutoff point?
Certainly, Your Honor. So again, I think the colleague is correct here that the underlying standard is taking evidence in the light most favorable to defendant. Could the jury conclude that the defendant was entitled to the Castle Doctrine and it would apply to him? He would be shielded with this type of immunity. It's not the jury question, stated differently, the legal question is not just whether it applies in the first place, it's whether also it has fallen off by rebutting of the kind of subsection C areas. And so in this case, had the defendant gone on the stand and said, oh yeah, no, I saw him trying to go back to the house. He tried to go back in when I fell down, because the defendant says he fell down, that's why he was a couple seconds late getting into the frame of the parking lot. Had there been testimony of that, maybe we would be in a different situation. Maybe we would be in a place where maybe this was a jury question. But even to say that it was a jury question, strongly that does not indicate prejudice under invited error, plain error, or even Strickland. There is no prejudice in this case, and there was no, frankly, legal error. Again, defendant was not an occupant of a protected area when he used deadly force. And even if he was, somehow through the perpetual kind of chain that my colleague tries to lay out, it was rebutted as a matter of law by the application of C5, because there was no evidence that the defendant was trying, or the victim was trying to get back in. There was a lot of evidence that the victim was simply trying to get out. He may have defended himself, he may have fought back at times, but he was not trying to go back, and there is no evidence to the contrary. I want to briefly touch on kind of, unless Your Honors have further questions about the Castle Doctrine or prejudice, I want to talk briefly on this kind of special instruction. I think, in essence, there are two It's a two-step analysis in any of these kind of instructions as to the victim. Does it apply legally? And two, does that impact the defendant's guilt or innocence? Setting aside whether it applies, because if Easter had been indicted in some way, yeah, maybe it would apply. In his case, maybe he wouldn't be able to claim certain things. I'm not sure. But he wasn't. And his legal liability for fighting back, for hitting him with a chainsaw at one point, has absolutely no impact on the defendant's liability as a matter of law. If I were to punch somebody and then they turn around and shoot me, setting aside Castle Doctrine protections, that almost certainly would not be allowed, even though my initial punch was illegal and I didn't act properly. The other person still failed the kind of proportionality of self-defense. And so to say that this is applicable here is just incorrect. As the state argued below, if we lead that to its logical conclusion, then Easter was supposed to sit there and just take it. For how long? For when? That doesn't comport with how we understand the kind of law of today. And then, of course, there's still the prejudice. Though this was preserved and submitted to the trial court, there's still a prejudice inquiry, and I find it hard to believe that the trial court or the jury would have rendered a different verdict if it had received this kind of unique special instruction regarding the use of force and when it's permitted or justified, as the statute says. And Miclemore makes that point clear as well in its use of defendant. My colleague says, well, that's just a product of what it was at the time, relying upon person in the statute. Well, be that as it may, again, the applicability of that statute to a theoretical indictment of Easter has no bearing upon whether the defendant could use force. It's a two-step inquiry, and he hasn't shown that second one. He hasn't shown that this would impact him at all as a matter of law. Your Honors, the Castle Doctrine is an important and powerful principle. As the Supreme Court noted in Phillips recently, they reiterated that idea, and it presumptively permits deadly force, and that is no small thing. But it is also narrowly drawn to permit only defensive force, not offensive force, as this court recognized in Coons as well. Defendants' proposed expansion to the Castle Doctrine would allow the exception to supersede the rule, where you get these almost perpetual license to kill, and that would inappropriately permit gun battles on the street, as Holloman reiterated is not what the General Assembly could have ever intended. Defendant's expansion has no basis in the language, and it undercuts the policy concerns of the Castle Doctrine itself. This court should therefore reject it. Instead, it should affirm the trial court's decisions below and find no ineffective assistance of counsel. Unless there's any other further questions, Your Honor, I respectfully ask that this court affirm the judgment below.
Thank you.
Thank you.
Your Honors, I think a number of the questions from the court went really to the heart of the matter. As far as the Castle Doctrine is concerned, the question before the court is not just the prejudice prong that we talked about. The question is, how do you look at all of the evidence in the light most favorable to Mr. Carwile? And I would respectfully disagree with the state that there was no evidence of an intended return to the house. I would point to a number of pieces of evidence. First, Judge Carpenter, you talked about the prior history between Mr. Easter and Mr. Carwile, and I think that's relevant. In addition, Mr. Easter, showed up to this home invasion armed, and he grabbed a weapon, a makeshift weapon, the chainsaw, and so I think all of that could, with all of that and his threat of "I'll be back," that showed an intent, or at least what Mr. Carwile could have reasonably understood to be an intent to continue trying to go into the house. Mr. Carwile also testified that he did think he saw another person there, and certainly no one else did. The jury was allowed to decide whether or not to believe that, but Mr. Carwile did say it, and there is at least supporting evidence in the record that there was another incident where Mr. Carwile had some sort of scuffle before this with someone else who showed up with another person in the car. So I think the jury could have listened to all of that evidence, as well as just understanding the fact that, yes, Mr. Carwile had been using drugs over the weekend, as had other people in the house. So had Mr. Easter. The toxicologist information given to the jury confirmed that he was indeed under the influence of meth, and I think jurors could have looked at this evidence and known that we have someone who has shown a history of animosity towards Mr. Carwile, who brings his own weapons and grabs whatever weapons he can see, and then does have a continuing intent to break into the house, and also is someone under the influence of drugs, which would make him a less predictable opponent. The state talked about what would have happened if there had been a gun in this scenario and Mr. Carwile had shot Mr. Easter in the house. That would be a less complicated analysis, but I would just note that the General Assembly did not say there are different rules for guns and everything else. The General Assembly said that Mr. Carwile was presumptively allowed to use deadly force. In this case, the deadly force was using whatever he had at hand because asleep or resting or going to get a drink of water, whatever the case was, he was in his home. He defended himself using whatever means were available. And using lethal force with whatever is available may take longer than with a gun. That might not be pretty to watch, but that's how lethal force worked in this scenario. And I would, again, the state talked about Mr. Carwile's testimony not being credible. That's a jury question. Mr. Carwile is not saying that this court should acquit him. What he is saying is he should have a jury trial where the jurors know the full scope of protection available to him under the law. And those protections do not allow the kind of endless struggle that could persist over multiple days that I heard discussed, because the General Assembly gave jurors an off-ramp to say that a home invasion ends and that the home occupant can't use deadly force anymore. That's the conditions given in C, in this case Part 5, that the state had to satisfy beyond a reasonable doubt. And the jury was the one that was supposed to be deciding whether or not that happened. I'll just briefly note that the Rebus case, it doesn't adopt doubtlessly as the standard. It just says more likely than not. The word doubtlessly is in further discussion in the case. But Mr. Carwile has met the standard for plain error in this case. The court can consider IAC as well for the reasons that we talked about. But the General Assembly has given homeowners a powerful tool to defend themselves. The jurors should have heard about it. And in this case, all we're asking for is a trial where those jurors know what the law was. And if the court has no further questions, thank you.
Thank you. I appreciate arguments of both counsel. Thank you. The case is submitted, and I believe we are ready to adjourn.
All rise. Court adjourned.